Zoom is back. The answer I got was, it is for now.
Fingers crossed.
All right.
Those two. Okay, so Professor Messamore, we were on slide 151, and
Correct.
Justice Hennessy had asked a question with respect to the latter part of that slide.
Yes,
Can you pick up where you left off?
yes, I can. Yeah, yeah. So as I understand, Your Honor asked about the phrase, the effect of the capital being allowed to remain in the statement of liabilities. And I said, I can't be certain about this, but what I would infer is that I should perhaps explain something that I haven't yet touched on, but will. And that is that for these annuities, what happened at the time of Confederation or the time of the debt allocation was that the annuities were capitalized. So they understood that they would in perpetuity have to pay for the Robinson treaties $4,400 annually. So capitalized at 5%, that means they had to set aside $88,000 so that it would forever yield $4,400 per year. So that's the concept I hadn't yet got into explaining, but it is kind of an important one to understand the whole process. And I think what would have happened then is in calculating the debts of the province of Canada, they would use the sum of $88,000 to represent that perpetual obligation to the Robinson Treaty claimants.
Of 4,400.
Correct. Yes, 4,400 annually. And so I believe, and I can't be certain about this, but the way it's phrased, I believe that what Casalt is referring to here for Quebec is that capitalization process. He said it would be unjust if Quebec bore that $88,000 in debt,
Or a
because
share of it.
a share of it. I'm sorry. Yes, a share of it, because Ontario would receive benefits from the land after Confederation, and Quebec would not.
Got it.
But
Thank you.
yeah, and this is why I think the whole set-off concept is important, because Ontario, Cameron, the Council for Ontario, made the argument that yes, that's true. Ontario would have, the Robinson Treaty territory is in Ontario, but the lower Canadian annuities, which represent a roughly equal sum, are with respect to territory in Quebec. So we can simply set one off against the other, and then there's no injustice. And I suppose the thinking is also that it would be simpler that way than treating it as an ongoing Section 109 trust, where Ontario would in future be obligated to pay a share of revenues based on their possession of that territory.
Thank you.
Justice Hennessy, I think, touched on this, Professor Messamore, but can you remind us what these actors, these Council for Quebec, Council for Ontario, and the arbitrators at the time, what was their understanding of the Robinson Treaty annuity obligation at that time?
Yeah, that's the thing I wanted to make clear, especially after, recalling that I used the term distinction or distinct or something like that last time, that they really didn't, from what I can see, consider the degree to which the Robinson treaties were different in terms of a share of resource revenue. They treated them as any other annuity obligation, thinking, I suppose, that the amount that could be capitalized to be paid in future was quantifiable, that they knew how much it would be. But of course, they really didn't, because the number of claimants was uncertain, and the dollar amount was uncertain. There was a lot of uncertainty around it, but there's no evidence that they appreciated that difference.
At that time.
Is that
Thank
what
you.
you're asking?
Yep, thank you. So we started with this being sort of a review of Quebec's position. And then I think if we could, you've already touched on it when you speak about the set off, but
Yep.
if you could just summarize for us again, then what Ontario's council's position was at this section
yes.
142 arbitration, which is on slides 152 and 153.
Correct.
And maybe you've gone through it, I think, already, but
Yes,
And I do find it easier to comprehend when you give your understanding of the quote, because we can all read the quote.
of course, yes. So, yeah, this slide 152 then speaks to Ontario's view expressed by Cameron, the Council for Ontario, that it would make sense to include all annuity payments in the province of Canada debt. And I should again clarify here, what we mean is a capitalized amount for future annuity payments, that those should all be considered part of the common pool of debt. Cameron said that for the so-called old annuities, the civil list annuities, if we like, the ones that were obligations that existed before the union. He said that the funds arising from the sale of those lands associated with those treaties went into general revenue. Lower Canada, meaning Quebec, or I suppose properly speaking, Canada East in the time of the province of Canada. That half of the province participated, they said, in an amount, so they enjoyed the benefits during that time, that the fund, he said, would have paid 10 times the amount of these annuities. So that's his argument as far as those old annuities, that Lower Canada's already received benefit from that. And if we can then move to slide 153. And then for the Robinson treaties, and again, I use that misleading language, distinctive here. They were distinctive, but distinctive in terms of timing, and not in terms of thinking about the nature of the treaties themselves. In that instance, Cameron said this would also be equitable to treat all future annuity obligations as common debt because of that offsetting annuity amount with respect to Quebec. So $4,400 annually that would have to be paid with respect to the Robinson treaties, and $4,000 for the Lower Canadian treaties. He, in this slide, my quote from him, he uses the term, he says a charge annually upon the revenue of $4,400 when he's referring to the Lower Canadian treaties. And that's because there was a permanent provision in legislation for the 4,000, but an annual vote for the 400 to bring it exactly in line with what was being paid under the Robinson treaties.
And I understand Professor Messamore will revisit this set off when we discuss how the later arbitrators.
Yes, yes, I'm trying to.
I'm not suggesting we do that now.
Yeah,
I'm just.
yes,
But can I?
yes, of course, yeah.
I'm just thinking about the answers to the two last questions.
Mhm.
And the first thing you said was Ontario's response, if I have it right.
Mhm.
Ontario's response was that the Lower Canada annuities were roughly equal to the Robinson treaties annuities,
Yes.
and that the Lower Canada annuities were with respect to a territory in Quebec.
Not exactly. The Lower Canadian treaties did, or sorry, the Lower Canadian annuities did not flow, as I understand it, from a specific treaty. It was actually, I understand, at the instance of the Governor General, Lord Elgin, who said that we have to make provision for Indigenous nations in Lower Canada And we set aside 230,000 acres for them. And we also provide an annuity of $4,000 per year, or as he said at the time, I think £1,000.
So was the annuity related in any way to the land?
I don't believe it was.
Okay, so it was, what did you call it? Provisions for the,
For the Indigenous nations of Lower Canada. I use the term Lower Canada, that wouldn't be accurate in this
Okay.
term, we'd say Canada East. Yeah.
so then I think you said, and also that would be simpler than treating the annuities as an ongoing Section 109 trust.
Yes, in my comment in that
Oh,
context.
just wait, I'm just not
Oh, I'm
finished.
sorry.
So you said that, or is that correct?
When you said that would be simpler, I'm unclear about that.
The set off.
Yes,
I'm saying
Yes.
Ontario's response was,
yes,
so it would be simpler than treating it as an ongoing Section 109 trust. Then here's where I'm
Mhm.
possibly confused from what you then most recently said.
okay,
That is where Ontario would in future be obliged to pay a share of revenues based on their possession of that territory. But the reason I raised that is because I thought most recently you said they didn't understand the treaties as having a link between annuities and resource revenues.
yes, that's correct. I
Do you see
think the
my
phrase
confusion,
that,
or-
Thank you for asking that question. It's
Okay.
easier for you to ask it,
Yes.
than me.
Okay,
It's hard to
then I-
explain without leading.
yeah,
So,
I-
but I understand your question entirely, so I'm happy to
Okay.
have Professor Messamore
okay.
clarify.
I, can you tell me my own statement that you
Well,
you
your
felt was
most
ambiguous? Yeah,
recent statement, and
Yeah.
you've made it a couple of times, I
Yeah.
believe, is
Yeah.
that and it may follow from a question that I asked a
Mhm.
while ago, that the Ontario officials did not necessarily understand a link between annuities payable under the treaty and revenues from resources.
Oh, from resources, yes, that is correct.
Okay, so if that's correct, what does it mean when you say that Ontario responded to the Quebec argument by saying it's simpler to do a set off? Maybe what do you mean? Simpler it would be easier to, or it would be simpler to do a set off than to treat the capitalized annuities possibly as an ongoing Section 109 trust, where in the future, Ontario would be obliged to pay a share of the revenues based on their possession of the territory.
Right. Okay, so let me just see if I can clarify the way I express this. The territory surrendered for all of the treaties resulted in annuity payments to the First Nations who were parties to the treaty. Generally, it was understood, as I believe, that the territory in which those surrendered lands were situate would receive benefits from that land. Those benefits were typically thought of in terms of land sales and other things, but typically land sales. And what I meant to imply was not that they were thinking in terms of a specific share of resource revenues with respect to the Robinson treaties. What I believe, not just Cameron, but everybody at the time of the Section 142 arbitration was thinking, is that in the future, Ontario will enjoy the benefit of these lands in whatever form.
Okay.
Does that make sense?
Thank you.
Okay.
I think then, I know we left off by me just alerting the court that the idea of setup, we will revisit it again later because it comes up again in the consideration of the later arbitrators in the 1890s. So
Yes,
we'll
it does.
revisit it then, and I think we are prepared to move off of it now. Which would bring us to where we were going to start today at slide 155, which is your comments on this whole section 142 arbitration. But before we actually do that, we need to jump ahead because there's one piece of the puzzle that kind of got out of order in the slide deck, and that is the capitalization of the Robinson treaties, which you've touched on. But let's go to 169, slide 169, because that's where you talk about the capitalization.
Yes.
169.
So what I say on this slide is that as part of the combined debt of the province of Canada, $88,000 was established as a capital amount that earning interest at 5% per year would yield income to pay $4,400 annually in annuities. And Ontario and Quebec were conjointly liable for this $88,000. So it would cover the fixed annuity, that $88,000 would cover the fixed annuity to be paid in perpetuity. $2,400 for the Huron Treaty annuitants and $2,000 for the Superior Treaty annuitants, estimated at 1,240 people, without there being any provision to cover an increase to $4 per person or more. So they simply capitalized it at the prevailing rate that was being paid without considering that that may not always be the amount.
Thank you. So then I think with that background, we can look at slide 155. And here and on the next few slides, you give us your comments on or your opinion of the relevant features or relevant takeaways from the section 142 arbitration. So can you take us through that?
Okay. Yeah, so perhaps I'm being repetitive here that I've said that the capitalization for the Robinson treaties of $88,000 counted as part of the province of Canada's debt was meant to cover the payment by the Dominion of the fixed annuities in the post-Confederation era in perpetuity, based on the amounts specified in the treaty.
And just to be clear here, the fixed annuities
Yes.
are exactly what?
So the, gosh, the sum, let me just, what was it? 600 pounds and 500 pounds. Yes. Yeah. Right. No, it's right here on the slide. And from 1867, the province of Ontario alone would derive the benefit of the proceeds of revenue from that land. And given the principles that were meant to inform the allocation of responsibility for excess debt, it would follow that Ontario should assume responsibility for this capitalized amount. So I'm talking about here in the arbitration process, using this local benefit principle.
And this is your idea, your comments.
Well, this is my, yes, I mean, this is how I summarize what I understand, their understanding would have inferred, I guess could we say that? I go on to explain in the next slide. I think it will be clear. On 156, I say, for this reason, it seemed logical to Quebec's representatives that the annuity obligations should be treated not as debt, but as a trust chargeable against the Crown lands under section 109. Alternatively, and this is again sort of my thinking of how it might have been done or could have been done, the amount might have been taken into account in the calculations of what portion of the excess debt was the responsibility of each province, given the local benefit principle that guided this process. And it could have thus been used to increase Ontario's share of responsibility for that joint excess debt. But instead, it was apparently determined that the availability of a convenient offsetting obligation, an almost equivalent annuity obligation in Quebec, stemming from 1851 legislation, made it possible to treat both of these capitalized amounts as part of the common pool of Province of Canada debt.
And slide 157.
This solution, however, ignored the possibility of a future increase in the Robinson Treaty annuities beyond the amount capitalized for. Such future increases seem not to have been contemplated at the time of the Section 142 arbitration. They say the quid pro quo arrangement only worked because the amounts considered were equivalent. Liability for any significantly larger sum due with respect to the post-Confederation era could not with justice be shared between Ontario and Quebec.
And this is your own
This
view.
is my own opinion, yeah. Excuse me, you mentioned that we would deal later with
I
this
think-
whole question of the offset coming up again in the Dominion provincial arbitration in the 1890s, is that?
Did you have a question, Justice Nancy, before we get here?
I do. When you say ignore the possibility of a future increase, do you say that the possibility of a future increase landing solely on Ontario, the obligation to pay possible future increase, do you say that is inconsistent with the principle of whichever province enjoys the benefit pays for it?
If I understand the question correctly, no. I would say that according to the principle that guided this process, it would make sense that any obligation for a higher amount in future would fall on Ontario.
So.
But-
I don't know,
but
the
what I-
the word ignored
Yeah,
sometimes suggests to someone's detriment or incorrectly or inconsistent with. Or is it simply, is it a coincidence that no one was contemplating a possible future increase? And in any event, it falls on the right province.
well, I would say that it's true to say that no one was contemplating a future increase. I think that in this section 142 arbitration, there were a whole lot of separate questions being considered. And I don't see any evidence to suggest that the arbitrators recognized that the Robinson treaties weren't simply any other annuities like the rest, where there was a fixed amount that would be paid in perpetuity.
Justice Hennessy, can
Go
I
ahead.
interrupt?
Yeah.
Your question suggested that something about the obligation falling on the right province. And I just want to remind,
Sorry, the province in which the territories were situated.
but here we're talking about the decision of the arbitrators in this case was that no, it should be split between both. Remember?
Yes, but then after the arbitrations, because the possibility of a future increase wasn't in anyone's contemplation. And then future increases came, but they became Ontario's responsibility.
We don't know that yet.
Oh, I'm sorry, I'm thinking of these future increases.
We don't know yet whose responsibility the future.
Increases will be. I knew that Quebec was not a defendant in this case, but I forgot that you might be here talking about something other than simply, or that
Well-
some might be talking about someone other than Ontario's sole
Well,
responsibility.
keeping in mind that the decision in section 142 is that the responsibility for these annuities is split between Ontario and Quebec.
Yes,
And of course, the alternative argument is that it's Ontario's alone. And
right.
yeah, but at this point, anyway.
Okay, that's
We're clear.
important to point out. Thank you.
Okay.
And you just said, Professor, that you saw no evidence that the arbitrators, is the word, recognized that there could be future increases,
Yes,
or were aware.
that is correct.
And if the arbitrators have that view, they could only have come to that view from the arguments or the facts that were put before them
Correct.
from counsel.
Yes.
So can we assume, this is a question to you, that Ontario wasn't highlighting for the arbitrators that there could be increases to the annuity?
Yeah, and I would actually go so far as to suggest that Ontario was also not contemplating it, not aware of it. In fact, later, when the issue of increased annuities became more widely discussed after 1873, that was something that Ontario cited. Well, nobody ever suggested before now that the amount ought to be increased or could be increased.
Thank you.
I had two questions following up from that.
Mhm.
The first one was just to tie the loop on if the alternatives being presented here, and really, when you look at the alternatives being presented by Quebec's council and Ontario's council,
Yes,
Quebec's council is saying this should all be Ontario's under section 109. Ontario's council is saying this should be the province of Canada debt split between Ontario and Quebec. And can you remind us, Professor Messamore, who would be responsible under section 111 of the Constitution Act for that debt?
so there was a common, or there was an amount of debt assumed by the Dominion government somewhere in excess of $70 million. However, Ontario, the province of Canada was given a debt allowance of $62.5 million that the Dominion assumed responsibility for. And the province of Canada was only jointly responsible for debt that exceeded that debt allowance.
And jointly responsible to who?
To the Dominion.
To the Dominion, thank
Yeah.
you. So
Yeah.
in effect, the Dominion, in a way, takes on the liability and
Yeah.
then can recoup from
That is
Ontario and Quebec.
correct.
Is
That is correct. Yeah, and the proportion of that was 53-47.
That might, I hope, Justice Hennessy, clarify the relevance of the various parties. Okay, so unfortunately, I forget the other follow-up question I had from your discussion.
We addressed the capitalization.
Oh,
We
I
addressed the
know, I
setup.
wanted to make.
Yep.
You had told the court that the arbitrators came to their view of the meaning of the treaty by virtue of what was presented to them by counsel's arguments. You remember saying that?
I think that's fair to say. I mean, the province of Canada would have had a record of all their obligations that would have to be considered.
But of
Um,
course, the arbitrators themselves would have had access to read the treaty themselves as well.
I don't know that they did. I'm not aware of that.
All right, thank you. So we were at, I think, slide 158 now. We can move to slide 158. And I think here again, you were talking about the set off amount. Did you want to go through that again?
Well,
Or
this
is
was,
that
this
covered?
was what was raised in the 1894 Dominion provincial arbitration, that they came back to that. Would you like to address that now, or should we wait to talk about?
I think we might as well tie in the loop, because I think
Okay,
here you
yeah.
deal with the $400 annual vote. So if you could clarify that
Okay.
for us.
Yes, so on slide 158, I say that later in the Dominion provincial arbitration in 1894, they again referred to this offsetting lower Canadian annuity. And it's relevant because it speaks to the intentions that informed the decisions of the 1870 arbitrators, and in particular, their decision to treat all the Indian annuities as common province of Canada debt. There's a lengthy transcript of the Dominion provincial arbitration, and it's ambiguous about who raised the point, but I believe it was Emilius Irving, counsel for Ontario, during the course of that arbitration process. He claimed, or sorry, whoever raised the point claimed that the $4,000 annual annuity payable to Lower Canadian First Nations had been in fact supplemented for a period of 10 years by an additional $400 annual vote. This enhancement of the annuities payable to Lower Canadian First Nations was evidently meant to match the $4,400 annuity payable under the Robinson treaties. Can we go to the next?
I think the next
sorry,
slide is
150.
actually just a quote from that transcript,
Oh,
and I don't
right.
think we need to read it.
Yes,
But
yes.
but could you maybe just put into your own words what the effect of this $400 annual vote was?
The effect of it was to make it equivalent to what was being paid with respect to the Robinson treaties, the annuity being paid.
And so I think that takes us to slide 160, where I guess you summarized this point. This again is your comment. Maybe you could take us through that. Oh, actually, no, I think, sorry, 160 talks about further evidence of your interpretation of this.
Yes, that's right. And so I cite the legislation, 14 Victoria, Chapter 106 legislation of 1851. That was the legislation that provided for that £1,000 to be paid to Lower Canadian First Nations. And I say that for a time, at least, it was made exactly equivalent to the Robinson Treaty obligation by means of a $400 annual vote. And that the Section 142 arbitrators intended to achieve a balance by considering both obligations as province of Canada debt. And I say it's explored in another document as well.
And that document you refer to at page 161.
Slide 161.
Sorry,
Yeah.
slide 161. And just for note, I included a copy of it in the compendium at tab 8. I don't think we need to go to it, though. I think the point has been made. Actually, you quote from it on the next page, 162. That might be the most efficient way to deal with this. Maybe you could just sort of take us through.
Yeah, so this was in the Emilius Irving Fonds in the Archives of Ontario, the document. We don't know, or at least I don't know, that it was written by him, but the ideas in this document echo the arguments he made during that Dominion provincial arbitration in 1894. And it just is, again, an illustration of the concept of set off. We see the amounts for the Robinson treaties at 4,400. And then he uses the identical language. He says under the heading Lower Canada as a set off to the payment made to the Upper Canadian Indians. Let's let's see. There was granted to the Indians of Lower Canada an annuity of $4,000, and from the public domain, 230,000 acres without price or payment, which at the moderate sum of $1 per acre would be equal to a grant from the public exchequer of $230,000, sorry. And these lands were actually set apart for the Lower Canada Indians as set forth in the schedule thereto annexed. But not content with this, it appears from the public accounts that the annuity paid from the public exchequer to Lower Canada Indians was supplemented with $400 voted annual.
And again, that the original document is at tab 8 of the compendium, but I think we've sufficiently covered it off here. Then we're ready to, I think, sum up on slide 163.
Yeah, I simply say on 163 that the arbitration decision was made by McPherson and Gray alone, Day having resigned, and that Quebec appealed this decision to the Judicial Committee of the Privy Council. And objected to the arbitration decision on 2 scores. One being that Gray had become a resident of Ontario.
And why was this a problem?
Because it was understood that he was, as the Dominion appointee, not to be resident in either Ontario or Quebec. And they also, Quebec also in their appeal questioned the validity of a ruling made by only 2 of the 3 appointed arbiters since Day had resigned.
And slide 164.
When these questions were ultimately brought before the JCPC, they in 1878 ruled that Gray's move did not disqualify him and that Day had no right to resign, and that the decision rendered by only 2 arbitrators was indeed valid.
And Day again
I'm
was,
sorry, the JCPC.
and Day
Oh,
again.
Day, I'm sorry, I think you said they.
Day-
Day was the Quebec appointee for the 142 arbitration.
Thank
Important to note here that the JCPC did not rule on the merits of the award itself, only on the validity of it rendered in those circumstances.
They didn't rule on it, but nor, from what I read, nor was it the subject of the appeal.
Yes, sorry, you are correct.
Okay.
Yeah.
And for reference, the actual decision of the JCPC is included at compendium tab 9.
Thank you.
So we're about to start a new section. I'm happy to keep going because we've had a break, but how does everyone else feel?
You can take a break.
Okay. All right.
Or recess for 15 minutes?